Welcome to the debate. If you look at a map of the world today, almost every inch of land belongs to a recognized sovereign state, with clearly defined borders.
Right. It's usually binary, very clean.
Exactly. It's clean. But there is a specific strip of land between the Jordan River and the Mediterranean Sea where those basic concepts, like a border, an occupation, or even sovereignty, they just completely break down under international law.
Yeah, it is the absolute definition of jurisdictional muddy waters. We are looking at a space where the physical realities on the ground, so geography, topography, and existential security threats, are in constant, violent collision with these highly abstracted international legal frameworks.
Which brings us to the central question we are exploring today. This is drawn from a comprehensive research dossier detailing the legal and historical status of this territory.
Right.
Is the international legal architecture unequivocally established this land as unlawfully occupied territory where Palestinian sovereignty must be restored? Or is it legally disputed territory where Israeli historical rights and acute security imperatives have to take precedence?
It is arguably the most complex legal debate of the modern era. I mean, both sides are operating with entirely different foundational premises.
They really are. So, to set the framework for this discussion, I will be arguing from the mainstream international law perspective. I'll contend that the Palestinian right to sovereignty is an unbroken chain in international law, stretching from the 1922 Mandate all the way to the 2024 International Court of Justice advisory opinion.
Okay.
And this architecture guarantees an inalienable right to Palestinian sovereign statehood, which basically renders Israel's nearly 60-year presence in the territories an unlawful occupation that has to end.
And I will argue from the Zionist and Israeli security policy perspective. My position is that Israel's presence is grounded in internationally recognized historical rights and, frankly, defensive security realism.
All right.
I will assert that the territory is legally disputed, not occupied, and that its final status can only be resolved through bilateral negotiation, not imposed by international courts operating in a vacuum.
Let's lay out the core mechanics of my position first. The legal foundation for Palestinian sovereignty is not some modern political invention. It is hardwired into the positive international law of the last century.
Meaning the Mandate era.
Right. We start with the 1917 Balfour Declaration. That document contained a vital safeguard clause explicitly protecting the rights of the indigenous Arab majority.
Well,
Let me just finish the timeline. That right was then codified in the 1947 UN Partition Plan Resolution 181, which legally recognized an independent Arab state alongside a Jewish state.
right, but
Because of that established right, the retention of the West Bank and Gaza after the 1967 war constitutes a prolonged unlawful occupation under the Fourth Geneva Convention. This isn't a fringe theory, it is the uniform consensus of the international community, affirmed by the historic July 2024 ICJ advisory opinion.
okay, but the problem with that timeline is that it totally misreads the foundational documents. The Balfour Declaration and the 1922 League of Nations Mandate did not invent a Jewish right to the land.
You're saying they recognized it
They displace a pre-existing sovereign Palestinian state.
Because you argue no such state existed?
Exactly, primarily because no such state existed. The text of the mandate explicitly talks about reconstituting the Jewish national home. And I mean, you can only reconstitute something that was already there.
Okay, but what about 1967?
Well, because there was no sovereign Palestinian state prior to 1967, the land captured in a defensive war is legally disputed. It's not occupied. And fundamentally, holding this territory is a vital survival shield for a state that is, well, only 9 miles wide at its narrowest point.
Let's look at the actual machinery of those early documents, because that is where the friction really starts. The Balfour Declaration is just 67 words, but it contains a massive internal contradiction.
You mean the safeguard clause?
Yes, it promises a national home for the Jewish people, but explicitly states that nothing shall be done which may prejudice the civil and religious rights of existing non-Jewish communities.
Right.
And keep in mind, at that time, the Arab society comprised roughly 90 to 92% of the population, When this was incorporated into the League of Nations mandate in 1922, it was governed by Article 22 of the Covenant, which created a trust.
A sacred trust of civilization, to use the exact phrasing.
Right. A sacred trust, and mechanically, think of how a trust works in financial law. A mandatory power, in this case Britain, acts as a trustee, holding the asset in abeyance for the beneficiary.
Okay.
A mandatory power cannot legally authorize the dispossession of a 90% indigenous majority. The legal right to self-determination belonged to the people living there. You can't just hand the trust over to someone else.
I have to stop you there because that ignores the actual specific phrasing of the diplomatic text you're relying on. Look at the safeguard clause you just mentioned.
Okay?
It deliberately protects the civil and religious rights of non-Jews. It explicitly does not say national or political rights.
Wait, are you arguing that the drafters just forgot to include political rights?
Not at all. In 1917, the diplomatic language of national self-determination was already widely understood. The drafters used it deliberately for the Jewish side, promising a national home, and withheld it from the Arab side, granting them individual civil protections instead.
That seems like an incredibly convenient reading of the text.
It's the regional mechanics of the time. The Arab population of Mandate Palestine was not viewed as a stateless, distinct nation in 1917. They were part of a broader Ottoman Arab population whose national self-determination was actively being provided for in a massive surrounding territory.
You mean the wider Middle East?
Right, what eventually became Iraq, Syria, Lebanon, and Jordan. Palestine was the one specific, tiny carve-out reserved for the Jewish national project. The legal framework was essentially one national home, many civil protections. To read a rival collective national right into the 1917 text is to read modern politics backward into history.
Okay, even if we assume the 1917 drafting heavily favored the Zionist project, the international legal architecture didn't just freeze in 1917.
True.
By 1947, the United Nations passed General Assembly Resolution 181, the Partition Plan. That is the first positive act of the international community disposing of the territory, and it expressly recognized an independent Arab state and an independent Jewish state as legally co-equal.
Which was rejected by the Arab side, leading to war.
Regardless of the political rejection, that right to self-determination was codified right there in law. And this conceptual disagreement over who held sovereignty directly causes the legal headache of 1967.
It absolutely does. Because from the Zionist legal tradition, the territory captured in 1967 is disputed, not occupied. And this is rooted in what is called the missing reversioner theory.
Wait, before we go further into that, missing reversioner is a pretty dense legal concept. Break the mechanics of that down for me. Who exactly is the reversioner in this context?
Right, so the entire law of belligerent occupation, like the 1949 Fourth Geneva Convention, is structured around a specific mechanism. An occupying power temporarily administers territory until it reverts back to the lawful sovereign who was displaced by the fighting.
Okay, so the displaced sovereign is the reversioner.
Exactly. Think of it like finding a wallet on the street. The law says you hold it temporarily until you can give it back to its rightful owner. But what if the idea inside belongs to a thief who stole it from someone else who no longer exists?
Oh, I see where you're going with this. Who do you legally give it back to?
Precisely. In 1967, there was no lawful displaced sovereign. It wasn't a Palestinian state. None existed. Jordan had illegally occupied and annexed the West Bank in 1950.
Which wasn't widely recognized.
Recognized by almost no one, not even the Arab League. Egypt didn't even claim sovereignty over Gaza. They just held it under military administration. The last lawful sovereign before them was the Ottoman Empire, which had completely dissolved.
So the argument is the land belongs to no one.
The legal logic is simple. If there is no lawful displaced sovereign to revert the land to, the territory cannot strictly be classified as occupied under Geneva IV. It is a disputed territory with an undetermined final status.
I mean, that logic treats international humanitarian law as a real estate dispute rather than a human rights framework. The missing reversioner theory is a fascinating academic exercise, but it has been aggressively and uniformly rejected by the entities that actually interpret and apply international law.
Well, they reject it because it complicates the narrative.
They reject it because of the purpose of the law. The International Committee of the Red Cross, the UN Security Council, and the ICJ all explicitly reject this. Why? Because the Fourth Geneva Convention was written in 1949 in the direct aftermath of World War II, specifically to protect civilians living under foreign military rule.
Right, but
The law protects people, not abstract state titles. Furthermore, UN Security Council Resolution 242 established the core foundational principle here, the strict inadmissibility of the acquisition of territory by war.
the 1967 war wasn't a war of conquest. It was a textbook case of anticipatory self-defense. Egypt massed troops on the border, closed the Straits of Tiran,
Which is a blockade, yes.
which is a classic mechanical trigger for war, a casus belli. And they formed military pacts with Syria and Jordan using explicit eliminationist rhetoric. When a state lawfully takes territory in self-defense from unlawful aggressors, it fundamentally changes the legal dynamic.
In what way?
You don't have to immediately hand the high ground back to the armies that just tried to destroy you.
Self-defense is a shield to repel an attack. It is not a sword to acquire land indefinitely. Even if you validate the anticipatory self-defense argument for the initial 6 days of the 1967 war, the law of self-defense does not authorize the retention of territory for over half a century.
It does if the threat never ends.
Holding millions of people under military rule for nearly 60 years ceases to be a temporary military holding pattern. It morphs into something else, legally.
And that brings us to the physical reality on the ground today. You see an indefinite holding pattern. I see security realism. Let's look at the map again.
Okay?
If Israel fully withdraws to the 1949 armistice lines, which, by the way, the 1949 agreements explicitly stated were just military lines, not international borders, Israel would be left a mere 9 miles wide at its narrowest point, 9 miles between the West Bank Hills and the Mediterranean Sea.
A 9-mile width is certainly a geographic vulnerability, I'll give you that.
It's the distance of a morning commute. Ben Gurion Airport, major infrastructure, and 70% of the population would sit within direct missile and small arms range of the high ground. The argument here is that survival is the prerequisite for any legal framework.
But that doesn't justify permanent control.
Let's look at the West Bank security barrier. Critics call it a land grab, but look at the mechanical history. During the Second Intifada, over 1,000 Israelis were killed by suicide bombers originating from the West Bank. The barrier was built, and suicide bombings dropped by more than 90%. It is a life-saving, adjustable counterterrorism instrument.
But if it's strictly an adjustable security instrument, why does it cut deep into the territory rather than following the armistice line?
The Israeli Supreme Court itself has ordered sections of it rerouted on proportionality grounds to lessen the impact on local populations.
Well,
Let me finish this point. That judicial oversight proves it is an administrative security measure, not a permanent political border. It is physical infrastructure reacting to a unique threat environment. It can be dismantled when there is a recognized security apparatus capable of preventing attacks.
see, that isolated view of the barrier ignores the broader systemic ecosystem of control. If we look at the 2023 Organization of Islamic Cooperation submission to the ICJ, they map out the mechanics of this beautifully. We are not just talking about a fence here.
We're talking about checkpoints, yes.
We are talking about the settlement enterprise, transferring hundreds of thousands of civilians into the territory, which is a direct violation of Article 49 of the Fourth Geneva Convention.
The counterargument being that citizens voluntarily moving into disputed land that has historical significance is not the forced transfer Article 49 was written to prevent after WWI.
But they are moving into a territory governed by a bifurcated legal system. The settlers live under Israeli civil law, while Palestinians in the same geographic space live under military law.
Due to their different civic statuses, yes.
But it ceases to be a temporary security holding pattern when you build permanent civilian suburbs and university campuses in the military zone. The OIC brief argues that these security measures, combined with land appropriation, constitute a continuing structural denial of self-determination. And self-determination isn't just a political suggestion, it is just cogence.
Hold on. Let's define the mechanics of just cogence for the listener before we move on.
Sure. Think of just cogents as the absolute baseline, constitutional rules of the planet. They are peremptory norms, like the prohibitions against slavery, genocide, or the acquisition of territory by force.
Right, the unbreakable rules.
Exactly. You cannot sign a treaty or claim a security exception to violate a jus cogens norm. Because the right to self-determination operates at this fundamental level, the structural denial of it transforms the Israeli presence from a temporary security administration into an inherently unlawful regime. It is de facto annexation.
I fundamentally disagree that security measures taken to prevent suicide bombings and mortar attacks equate to a structural denial of rights. Every checkpoint, every permit, is a mechanical reaction to a localized, documented threat.
This clash between on-the-ground security realities and peremptory norms of international law is exactly what triggered the unprecedented 2024 judicial proceedings at the International Court of Justice.
Unprecedented is the right word.
52 states presented oral arguments, and the court's July 2024 advisory opinion was an absolute watershed moment.
It was an advisory opinion, requested through a highly politicized UN General Assembly vote.
Yes, it was advisory in its mechanism, but let's explain how that functions. While it isn't a binding order on a specific state in a way a contentious case is, it is the highest authoritative articulation of what international law actually is. Okay, but let me just lay out the finding. The ICJ found that Israel has an obligation to end its unlawful presence as rapidly as possible. Crucially, the mechanics of this ruling activated third state duties.
Meaning other countries have to act.
Exactly. It established that every other nation on Earth now has an affirmative obligation of non-recognition and non-assistance regarding the occupation. The UN General Assembly followed up with Resolution ES-24, setting a hard 12-month deadline. This is the international legal architecture demanding compliance based on objective legal standards.
Objective legal standards? The 2024 ICJ proceedings represent a profound structural bypass of bilateral diplomacy. There are massive jurisdictional flaws here, specifically the monetary gold principle.
Stop right there. What is the monetary gold principle in this context?
It stems from a 1954 ICJ case. The principle is a foundational rule of international jurisprudence. A court basically cannot adjudicate a legal dispute regarding a state's interests without that state's explicit consent.
Right, it prevents trials in absentia.
Exactly. Israel did not consent to this ICJ jurisdiction.
But as you just noted, this was an advisory opinion requested by the UN General Assembly. It wasn't a contentious lawsuit between two sovereign states, so consent isn't required in the same way.
Side, the effects of Hamas rule in Gaza or the decades of rejectionism.
The court answers the questions it's given.
Right, and if you ask a court only one half of a legal question, the outcome is mechanically predetermined. But more importantly, relying on the ICJ and the General Assembly completely bypasses the binding agreements both parties actually signed.
You're referring to the Oslo Accords.
The Oslo Accords, along with Security Council Resolutions 242 and 338. These legal frameworks specifically mandate that permanent status issues, borders, security, settlements, must be resolved through a negotiated settlement between the parties.
Well, negotiations haven't worked for decades.
But a General Assembly vote cannot magically alter binding bilateral treaty obligations. You cannot litigate your way to peace from a distant chamber in The Hague while ignoring the security reality on the ground.
But that argument essentially places bilateral politics above the foundational rules of international law. To summarize the overarching framework of my position, Palestinian sovereignty is an inalienable right codified by a century of legal mechanics, from the mandates trust concept to the 2024 ICJ ruling.
Right.
When a situation violates peremptory norms like the acquisition of territory by force and the denial of self-determination, political accommodations or bilateral negotiations cannot simply extinguish those legal rights. An unlawful occupation doesn't become lawful just because the occupying power demands a negotiated exit exclusively on its own security terms. The law dictates that the rights must be restored.
And to summarize my framework, you cannot abstract this conflict away from history and geography. The Jewish historical connection to the land is internationally recognized, not newly invented.
Okay.
The territory is legally disputed because there was no prior sovereign state of Palestine to revert to under the Geneva framework. And above all, existential security realities cannot be overwritten by non-binding advisory opinions that ignore the context of defensive wars. Withdrawing without guaranteed negotiated security arrangements would expose a 9-mile-wide state to existential threat.
Which is why security is always part of the discussion.
But peace has only ever been achieved in this region through direct face-to-face bilateral negotiation, like with Egypt in 1979 and Jordan in 1994. That is the only mechanism that actually works.
We clearly have a profound ongoing disagreement here, particularly regarding the mechanisms of international law. You view international advisory bodies as abstractions disconnected from security realities. I view them as the absolute baseline floor for any legitimate political arrangement.
We do disagree on the supremacy of those bodies versus bilateral treaties. However, I think there is a point of conceptual convergence between these two frameworks.
Oh?
Both perspectives, when you drill down into their most sophisticated forms, ultimately recognize that the current status quo isn't a permanent mechanism. A sustainable future eventually has to address both the national aspirations of Palestinians and the very real physical existential security needs of Israelis.
I agree with that. Any lasting resolution cannot simply ignore the legal rights of millions of people, just as it cannot ignore the genuine geographical and security vulnerabilities of the region. Examining the strict international legal documentation alongside historical security realism gives us a much richer understanding of why this conflict is so legally intractable.
There is so much more to explore in the source material. The drafting histories of the League of Nations, the military strategies of 1967, and the specific mechanics of the court rulings we touched on today. They all warrant much deeper investigation.
So we circle back to where we started. We are looking at a geopolitical landscape where the lines are drawn not just in ink by surveyors, but in history, trauma, and competing legal rights. The map remains incredibly complex.
The muddy waters remain.
We will leave it there for you to weigh the evidence. Thank you for joining us.